Hello everybody and welcome to Alan History Nerd. In this video I'm looking at US politics. In particular I'm looking at the nature and the role of the Supreme Court. This is part of my playlist on A-level politics and also part of my other playlist on US politics. Hopefully this video will help you get an understanding of some of the key basics about the Supreme Court. If you're interested in all other aspects of A-level politics, then please check out my playlist, and if you haven't subscribed to my channel, please do so. So this is part of the A-level specification from Edexcel, and it's in component 3A, 4.1, nature and role of the Supreme Court, the US Constitution, the independent nature of the Supreme Court, judicial review process, Marbury versus Madison 1803 and Fletcher versus Peck 1810. So I'm going to look at all those different bits and make sure you've got an understanding of this first key part of the specification on the Supreme Court. The US Constitution, then, it gives, well, very significant powers to the Supreme Court. Obviously not all of the Supreme Court's power actually comes directly from the Constitution itself. Some of it comes from some acts, or some key things about it come from acts of Congress, and some of the power the Supreme Court gave to itself, which is a little bit odd, but more of that later. So basically, the Supreme Court plays a hugely significant role in US politics. It is the highest court in the country, and it has the key job of interpreting and upholding the Constitution. The Constitution gives it judicial power, and this is then shared with the inferior courts through Article 3 of the Constitution. The Constitution states that the Supreme Court will rule on constitutional issues when they happen and are brought to them, but not initiate them. So the Supreme Court cannot decide, we think that's unconstitutional, and do something about it. Somebody actually has to come to them and complain about it. Now, any US citizen can challenge a law or an action as being unconstitutional, and that can ultimately end up in the Supreme Court, but not necessarily. It won't necessarily end up in the Supreme Court, but it can. It has appellate. It has appellate jurisdiction, which means the Supreme Court is the ultimate court of appeal in the US. It also can have a form of original jurisdiction, so it is possible actually for a case to be heard in the Supreme Court without having been heard elsewhere before. So it's not just an appeal court. And that is particularly true when it's hearing, for example, disputes between federal and state governments. Judges are nominated by a president and ratified by the Senate, and they're appointed for life, and we'll look at that as one of the key ways in which the independence of the court is maintained. Now, the acts of Congress that have played an important role, essentially they've been used to set up these inferior courts, and they've all been created by acts of Congress. There are 13 circuit courts. These are appeal courts. 12 of them are regional, 1 of them is federal, and that they sit below the federal court. They sit below the Supreme Court. Below the circuit courts or appeal courts, there are 94 US district courts, as well as the Court of International Trade and the Court of Federal Claims. The 94 districts also have bankruptcy courts as well. The court system essentially is all set up in like a pyramid. It's set up in a hierarchy with the Supreme Court at the top. So ultimately, if a case keeps on being appealed and the Supreme Court decides that it is of enough importance that it can ultimately be seen in the Supreme Court, but as I mentioned before, you do occasionally get cases that go straight to the Supreme Court, but that is more unusual. Another important role Congress played is in determining how many court justices there are. Now, this isn't actually specified in the Constitution. So the idea of having 9 members of the Supreme Court goes back to 1869, goes back to a point where Congress was in conflict with the then President Andrew Johnson about all the issues of Reconstruction and how radical that Reconstruction should be, and whether it should be controlled by Congress or whether it should be controlled by the President. And Johnson ends up getting impeached and just survives and then loses an election. So the number of Supreme Court justices actually over time has varied. It's been as low as 5, it's been as high as 10. So it's set by Congress at 9 in 1869. Now this is really significant because actually it means the number of Supreme Court justices could be changed by Congress. Now, Franklin Delores Roosevelt actually requested a change at a number of Supreme Court justices because they were getting in the way of his New Deal. And that got rejected by Congress. There has actually been talk amongst some Democrat supporters that they should seek or could seek to change the law in Congress on the number of Supreme Court justices, just because the more progressive, more liberal judges are so outnumbered on the Supreme Court. The Supreme Court's generally judged to be 6-3 in favour of Conservatives at the moment. And so that might be a way of retaliating. It's all to do with the fact that the Republicans blocked the appointment of Merrick Garland whilst rushing through the appointment of Amy Coney Barrett right at the end of Trump's term in office. So that is a possibility, but it seems a bit far-fetched to me. I think that's highly unlikely. That might well be famous last words, and I might be doing a video in the future going, I said this and it was wrong, but it seems like an unlikely scenario to me. The independent nature of the Supreme Court is really important. Separation of powers are clearly, if you go back to the stuff on Constitution, so separation of powers is a very important principle in US politics, and there are several measures to ensure the independence of the Supreme Court. Now, the judicial branch is completely separate from the executive and the legislative branches, and has no shared membership. So you can't be a member of the Supreme Court and in Congress, or President and Chief Justice, or anything like that. And also, the whole system is set up to minimise the opportunity of people from the different branches working together, and therefore the Supreme Court doesn't really work with the other branches. So there's not really any opportunity for them to apply pressure. Though that doesn't mean that presidents, for example, haven't tried in the past. But the appointment process is also set up to stop a president acting alone. Their nomination has to be ratified by the Senate, and there's ratings given by the Bar Association to ensure that it's an appropriate, qualified person that is going on to the court. And the Senate, if they think the president is acting inappropriately and who they're nominating, they can just block it. A really important aspect also is the life tenure. So becoming a Supreme Court justice is quite an unusual job to get, and it's got a really unusual element to it in that you are appointed for life. And so essentially, unless you break the law or choose to resign, that's it. You are a Supreme Court justice. So neither the President nor Congress can remove you or threaten you with removal just because they disagree with your judgments or don't like you. They can get rid of you if you act illegally, but they need a supermajority, 2/3 in both houses of Congress to do that. There's also a nice little bit in the Constitution that protects your salary, so your salary can't be reduced through over time of being a Supreme Court justice. I don't think it actually set the wage level all the way back when the Constitution was written, otherwise it wouldn't be a very well paid job, would it? So I assume it's all kept up with inflation. It's a well paid job, I'm guessing. But a president or Congress that doesn't like what you're doing can't solely just cut your wages to make it impossible for you to continue. Now, the next part I look at is really quite a controversial one. It's this area of judicial review. I look at the process and the power that it brings. Now, the whole process of judicial review is really significant. So, for example, the Supreme Court receives far more cases than it chooses to hear. So it might get 8,000 things presented to it a year, and it'll choose to hear the 100 that it thinks that it's most appropriate for it to hear. And again, there's no set number it has to look at, actually. And when it hears a case, they act very much like a normal trial. There's a defendant and a plaintiff, and they present their evidence, and the 9 justices sit in judgment. And the decisions are taken on a majority basis. So again, if you get a 5-4 split, then you have a majority vote, and therefore that decision will carry. You also then will get a written opinion, definitely of the majority, and in most cases you get a minority opinion that are published, and these can be really important for setting the precedent and how far the Supreme Court decides to go and how long these written opinions are. It can determine how far this judgment impacts on what other things are going to come down the line. And they might take it's a very narrow judgment on a very tight part of the Constitution. They might take it as something much broader, and it might therefore have a more significant impact going forward. The Supreme Court has the power to strike down laws made by either federal or state government if they deem it to be unconstitutional. Again, and we'll look at the origin of that shortly. The Supreme Court can, in effect, update the meaning of the words of the Constitution with its judgments. So those majority opinions, in particular, they start to form essentially part of the Constitution going forward. And this has meant this power of judicial review means that the Supreme Court has made some really important decisions on things like civil rights, with Brown versus Board of Education of Topeka, and abortion with the Roe versus Wade in 1973, and on other issues such as free speech online, because obviously the Constitution doesn't talk about what you can do on the internet. Now, the Supreme Court has also reviewed elections, and we saw this in the most important case of this is probably Bush versus Gore in 2000, and there were some cases raised in 2020, but rather rapidly dismissed. So where does all this power go back to, this kind of implied power, this power of judicial review? Well, essentially, the Supreme Court gave it to itself, and we go all the way back to Marbury versus Madison of 1803, and this is the beginning of the idea that the Supreme Court could deem the actions of any other institution as being unconstitutional. So the case was based on a dispute between the Federalists and the Democratic Republicans. So John Adams had been a Federalist president. He'd lost the election of 1800, but before the guy who replaced him, Thomas Jefferson, who had come home by that point, before he could be inaugurated, what John Adams did is he appointed a load of judges to the various circuit courts. That might sound familiar as an idea, that just before you're just about to lose, or you lost, or just about to lose an election, you appoint significant judges. So Adams did this, and the idea was it was going to get in Jefferson and his time in presidency, was going to get in his way, because he was going to appoint a load of judges who were pro-Federalists, who'd support the Federalist Papers. And one of these judges was William Marbury. Now, James Madison was a close associate of Thomas Jefferson, and had been main Secretary of State. And Madison refused to deliver the commissions to these judges who had been appointed right at the end of John Adams's term. And essentially, the court ruled that he'd acted illegally. So here we have the judicial branch censoring and preventing the actions of the executive branch, and saying, right, no, you can't. These people have been appointed in good faith and within the rules of the Constitution, so you can't stop them taking those posts just because we've had a change in the presidency. So again, we see the Supreme Court interpreting the Constitution as actually giving itself a bit more power. This was further emphasised with Fletcher versus Peck in 1810. So again, this is a slightly different case, but it's this idea of judicial review, and it's the first time that the Supreme Court had overturned a state law. The case revolved around Georgia's state legislature repealing the Yazoo Land Sales Act. Now, there'd been a lot of corruption surrounding this, and so the legislature had been voted in. There had been the corrupt sale of this land. There's an election. The new legislature's been voted in, and it overturns it. That all seems fairly straightforward. But for Fletcher versus Peck is then a dispute over the land, saying, well, because the act's been has been withdrawn, that means that the contract of sale doesn't stand, that they bought and sold land, and it came back and said, no, actually, even though the law wasn't valid, although that law had come out through bribery and corruption, that it was still the law, and therefore contract law was still binding, and that's the contract law section of the Constitution is Article 1, Section 10, Clause 1, as I'm sure you all know. And that, therefore, was an important part of going, well, actually, the Supreme Court can go to a state and go, no, that law is, that rule, that action is unconstitutional. You can't do that. And we see this then as a really important staging post in the growth of the power of the Supreme Court. So as I said before, judicial review, it's a controversial power, and it's a controversial power because essentially the Supreme Court gave it to itself. Now, it's the Supreme Court a long time ago giving it to itself, and it's had really important ramifications since. But defenders of judicial review and the Supreme Court on this issue say, well, actually they need that power to be able to uphold the Constitution, and therefore it is right that they have it, even though it isn't there in bold type on the Constitution document itself. I hope that's been really helpful for you and given you a kind of an understanding of some of the very basics about the Supreme Court. This is part of a series or playlist on US and A-level politics in general, and I will be continuing through. So there will be more videos, depending on when you watch this. There already are more videos, or there will be more videos on the Supreme Court. There are also a whole series of videos on Congress and the President and elections, and then loads and loads of British stuff as well, and some ideology stuff. So anything you could possibly need, some technique stuff, how to do the different types of questions, how to do the different AOs, how to get a top grade. There's loads and loads of videos on the playlist, so please check all those out, and if you haven't done so already, please subscribe. Thank you very much for watching.